Well, thank you very much for that generous introduction. It's a pleasure to be back talking at ALTA again, of course, from the academic's perspective on legal research. And what I've been asked to do in particular is to talk a bit about the major purposes of legal research, some of the trends, some of the constraints. And like any good academic, I thought I should start by trying to get a sense of what we're talking about. What are we talking about when we refer to legal research? And like any of my students, I went immediately to Google to determine the answer, which took me to Wikipedia. And from there I discovered the great work by Jacobstein and Mirsky, The Fundamentals of Legal Research. And they define legal research in its broadest sense as being legal research including each step of a course of action that begins with an analysis of the facts of a problem and concludes with the application and communication of the results of the investigation. That left me none the wiser as to what legal research really is, and so I've attempted to give a sense of legal research and some of the trends by instead doing something that's becoming increasingly prevalent in the legal academy, and that's talking about methodologies. Something that anyone who applies for grants needs increasingly to engage with. That is the way we undertake legal research. And for me, that's a much better way of describing what academics do when we fulfil that function. The five main categories, I think, that describe the methodologies of legal research are today, firstly, the one we're all well aware of, that's doctrinal legal research, the black letter research that Justice Sackville has referred to. And that, of course, understandably remains and must remain the bedrock of almost all legal research, a clear understanding of the legal rules and legal institutions. But nonetheless, I think it's fair to say that this form of legal research is much less prevalent than it was. And in fact, in many parts of the academy is declining in terms of it being a central part of much legal research. It's necessary and important, but other methodologies are becoming more important and prevalent. The second form of legal research that's often referred to is, of course, theoretical legal research, people looking at the writings of Foucault through to Dworkin. And it's now become almost commonplace that if you want to write a PhD within the academy, you'd better have a theoretical chapter. It's not mandatory, but it's close, and that's one of the big shifts, I think, in legal research that will play out over the coming decades. The people we are training to become legal academics are seeing as almost mandatory the idea that they engage in theoretical work, whether it be public law focused or other focuses. This is one of the big emerging trends. Thirdly, empirical research. And of course here we're talking about a variety of things such as interviewing participants in the legal systems, analysing data. And this is becoming increasingly important to legal academics as we try and connect legal problems with the lived experience of the law. It's something that academics have not done a lot of in the past, but I think when you read what's coming out in the journals and elsewhere, people are understanding the need for this type of research and the need for it to be done more and connected more to theoretical and doctrinal work. Fourthly, I think one of the biggest shifts in recent years is a move to comparative legal research. This is where the technologies have changed the game radically. It's not just a matter of accessibility of legal materials, as Sarah has so graphically illustrated, but the accessibility of a broader range of legal materials. If I want to know what's in the Constitution of Swaziland, it's pretty easy to find that out. In fact, it's not hard to find what's in the Constitution pretty much, I suspect, of any nation of the world, whereas previously that form of legal knowledge was almost completely inaccessible to someone such as myself. Within the field of constitutional law, it's radically shifting the parameters of what it means to do constitutional law research, and it's had a very positive impact within Australia in, I think, weakening what has often been a very strong sense of parochialism about our system of public law, forcing us to open up to other systems and gain a greater understanding of how they operate and how ours operates in perspective. And finally, interdisciplinary legal research, which is one of those types of legal research involving political science, psychological and other perspectives, in fact any perspective you care to name, that we all know we should be doing more of, but at the moment I think it's fair to say the Academy has not quite got its mind around as to how it can really grapple with the full implications of good interdisciplinary research. I read a lot of work in the journals, and I often find that the interdisciplinary research is the most original, most novel, partly because those methodologies are still very much underused, and I think that's where we as researchers have more work to do to engage with other scholars, as I think American law schools tend to do better. Now, of course, that's just a brief description of some of the main methodologies and some of the trends, and I think it's fair to say that things go in and out of fashion. There are changes of emphases, but it's also fair to say that good legal research using any or all of these tends to stand the test of time. And Something for me that's a good example of this is actually Justice Sackville's landmark legal research in the 1970s on law and poverty, which still today is often used in talking about those issues within good legal research. The trend today, I think, when we look at what's happening more broadly, is to use a number of these methodologies and asking increasingly complex sets of questions about how the law works and how institutions engage with the law. We're also seeing changes because of the growing size of the academy. We're seeing changes because of the new technologies coming through, a diverse range of international approaches having their say, and also the fact that team-based research is now increasing markedly as a component of the research being done in Australia. I don't have the statistics. Russell Smythe may well be doing this, you never know, but I wouldn't be surprised to see there's an exponential growth in the number of multi-authored legal research papers over the last 10 to 15 years as people work increasingly in groups and increasingly in groups with postgraduate scholars, as I certainly do myself. My own research is a good example of this. The main focus of my current research is asking a series of questions about Australia's anti-terror laws and how those compare to those of other nations. My research has questions such as, are our anti-terror laws effective in meeting their stated goals? Do we have sufficient checks and balances, oversight and review for protecting fundamental values such as freedom of speech? To what extent are exceptional aspects of our anti-terror laws now being applied elsewhere, such as in bikie laws? And more broadly, has there been a fundamental historic shift in democratic public law systems by virtue of the anti-terror laws passed since 2001? Now, these are the sorts of questions that really involve all of the different aspects of legal research that I've talked about. You need to understand the laws and have a very fine appreciation for the difficult legal questions raised by those laws. You need a solid theoretical understanding of how they operate within conceptions of democracy and public law. You need some empirical data on how they operate in practice. And of course, you need a very good understanding of comparative analysis and laws elsewhere. And it's an example of a project that's a very modern project in terms of its scale. It's supported, in my case, by an Australian Research Council Laureate Fellowship, and all up, the team of people that I work with numbers 12 of the people who work on these questions, including 5 PhD students, postdoctoral students, full-time academics, and others. And all of those people's salaries are paid completely by the Australian Research Council. We have essentially a size of a team that is only a bit smaller than some law schools in this country, dedicated purely to the task of legal research on this particular set of questions. And it shows, I think, particularly how funding is driving a move in the legal academy towards some of the science-based models of engaging in legal research, and whereby you'll see, particularly from our team, a host of multi-authored publications to fully recognise the contribution of a range of people working in those areas. Now, that's an albeit extreme example of legal research in that area, but nonetheless I think it does grapple with some of the themes and changes we're seeing, driven in part by changes in the funding landscape. What I wanted to also do, though, in talking about some of those recent developments and that are driving legal research, is also talk about some of the problems that are emerging from that relate particularly to the themes that we're talking about in this session today. What I see is that there are quite strong forces and incentives at work that are driving legal research to be increasingly relevant to the academy, with a lesser necessity or a lesser requirement that legal research is useful or has an impact outside of the academy. I think some of these drivers are very long-term drivers and have always been there, that mean that legal research is often valued most when it's read by our peers and is valued most when it's published in places that academics will read and engage with. And if it's actually used externally to the academy, well, that has its benefits, but it's usually and often not seen as significant or as important as that academic impact. And I know in my own case that some of the most important legal research I do doesn't easily fit into the category of being the high-grade legal research within the academy. For example, the book I have done with Tony Blackshield, Australian Constitutional Law and Theory, is probably the most significant contribution I have made to legal research. But as a textbook, a casebook, it doesn't actually even get counted anymore in terms of being tallied as a work of legal research. I can spend a year updating that book and it's not counted when it comes to asking the question, is this a worthwhile contribution to legal research? That, incidentally, is the book that is most cited of anything I've done by the courts, by Parliament and by external agencies to the academy, yet it's one of many examples that can be given of legal research that is actually given relatively low weight. Now, that matters, of course, particularly if you're someone in the academy who wants to be promoted and you are thinking about what publications you'd like to have to make the best case to your peers about the value of your legal research. And we have drivers and systems within the academy which unfortunately are valuing research in ways that I think actually work against some of the themes of this session, and that is producing legal research of broader impact and broader relevance. I think the danger for us is that we will continue to go down the American path, where there's a very high propensity in America to produce research which is almost unintelligible in some fields to those outside of the narrow confines of that academic subdiscipline. And that type of research undoubtedly has its value and is important. But if it dominates, then I think we do ourselves a great disservice in terms of our capacity to influence and to be relevant outside of the university corridors. Unfortunately, these pressures towards producing a particular type of research are being exacerbated by recent government changes. I'm sure you're aware of the ERA, the Excellence in Research Initiative, where our disciplines within universities all get ranked on a scale of 1 to 5. And I should say, by way of disclosure, I was on the panel that ranked law schools in the last round in 2010, 1 to 5, but I'm not involved on this occasion, thankfully. That exercise is fundamentally reshaping how legal research is done, because it is sending signals to deans and university administrators about the types of research that needs to occur within universities. There's not a direct funding correlation yet, but it's the most powerful indicator, if you like, for universities of what should and should not be done. Now, it's very useful in some regards. I actually support, for example, the move towards journal rankings. I think they're flawed in many ways in the last iteration, but transparency about where to publish and what to publish is very useful. It's also useful in giving us a sense that quality research means innovative and original takes on legal questions, that we have arguments and findings with a high level of analysis, clarity and precision, that we produce new knowledge and understandings, and that we produce research that is persuasive within the academy. But there's one indicator that cannot be used in determining what is the best legal research in Australia, what is excellence in legal research. And that is, it is impermissible to make that judgment by determining the impact of legal research on things such as government policy, legislative change, common law development, and more broadly, institutional behaviour. You just can't use impact. It's not one of the measures that can be used to determine these rankings. And that sends a very strong signal on the current construction of this program that those are things that may have value but not the highest value, and indeed universities need to be very careful in giving that type of research high weight because it won't be valued in terms of that ERA exercise, and I've certainly seen that very directly firsthand. What that means is that the long-term drivers to produce research that is of most use to academics are now being accentuated through the ERA exercise. And I think unless there are changes, and there are possibilities the government will move to an impact measure as well, that we will increasingly move away from recognising the high value of producing research that is of use outside of the academy. And I think this is where it gets to the goals of legal research. I think in asking why do we do legal research, well, clearly we need to do it to develop our knowledge, deepen our understanding of laws and legal institutions. But also I think one of the important goals of legal research is that we contribute towards the formulation of better laws, more robust legal institutions, and justice and equality within the community. My own experience is that legal research often has the greatest impact not in courts and in the legal profession, but when it comes to decision making in parliaments. And that's for the simple reason that, as has already been identified, statute law is increasingly becoming a dominant form of lawmaking, if it is already not that form within Australia. In many fields, if not most fields within the legal academy, if you really want to have an impact on the construction of the law, you need to do it through influencing Parliament. Yet I'm constantly surprised by the very small number of academics who ever make a submission to a parliamentary inquiry. I found the greatest take-up of my own work is through submissions to parliamentary inquiries. They are so hungry to hear good construction of legal knowledge that can help them draft laws and solve difficult policy problems. It's how I've been involved in things such as the Victorian Charter of Human Rights or changes to Australian anti-terror laws. Very little point engaging in courts or the legal profession for those type of changes. You need to get involved through parliamentary processes. And I think here academics greatly understate their potential impact. Law reform bodies have already been talked to, but again, relatively few academics make submissions to law reform bodies, even where they have researched directly on point that can be moved to deal most obviously with the question that a law reform body is engaged with. Here again, I think we undersell the potential impact of our research. There's a range of executive officers who I think we ought to be writing for as well. In my field, the new Independent National Security Legislation Monitor, Brett Walker from the New South Wales Bar, holds that position. He's someone who's made it very clear he needs good legal research to help him write his reports about how Australia's anti-terror laws should or should not be changed. And in fact, a lot of our current work is directed towards assisting him to write a body of research in good journals that can help him make those decisions. And finally, I think we should be writing for the community, helping people to more broadly understand the law. In my own field of constitutional law, I think there's a right of the community to understand their democratic processes. And influencing public opinion, I think, is one of the very important roles that legal research ought to play. Well, finally, I just wanted to say, well, if we're writing for those broader audiences, what do we need to do to make a shift, to make our work more accessible to those audiences? And there's a couple of things, apart from simply being open to the opportunities and being willing to go against the grain of often what universities suggest is the appropriate form or format for our research. The first thing I think we need to do is take the radical step of being prepared not just to publish in the traditional academic forums. We need to be prepared to publish in places that are read by people outside of the academy. And it's surprising how few academics actually do that. I would typically write an academic article in a journal and then rewrite that material, perhaps for the media, perhaps in submissions, perhaps for a law reform body. And in fact, the difficulty is quite minor in terms of adjusting what's already been done to translate it for different audiences. But when I speak to people, they mostly assume that people will find their research by searching the journals and that the research will come to light. It just doesn't work that way. It's hard enough for us to read the research in our field, and the assumption that others will look for it in academic circles is almost always wrong, in my experience. In fact, it's pure luck in many cases if the right piece is found by the right people. I think also academics need to be just very pragmatic. If you write something that's useful to someone, send them a copy. In my experience, people will read material if you send it to them, and if you send it sometimes to a parliamentarian, a judge or others, they will read it and you may well find it being used for that reason. If you don't send it, I'd work on the basis it's not likely to be read. Yet again, in my experience, very few people do that. And the second more broader point is I think academics also have to seek to produce research that not only identifies problems and often abstract solutions, but to take the next step of indicating how specifically and pragmatically the law needs to be changed. You need direct and I think practical responses to problems that often academics are concerned about doing in their fields of endeavour, and that leads to a sense of frustration often with the usability of academic legal research. Identifying specific answers, particularly in things like legislative drafting, can require courage, boldness and clarity, but it's simply essential if you actually want to be influential and have an impact and have your legal research used in these other places. My own experience is you can get it wrong, but people nonetheless admire the fact that you've actually had a go and will engage with your work for that reason. Well, to conclude, academics often like to see their ideas have an impact on law and legal policy, and we like to think that what we write will contribute to those broader goals of legal research, a just society, more robust institutions, and a healthy dimension to the law. I think, however, there's a lot we need to do to achieve that, including changing the rules that operate within the academy and being prepared to go against the grain to actually produce research that doesn't just work towards a 4 or a 5 in the ERA rankings. But I think it can be done, and I think there's a lot to be said for doing it. And I think if we do, then there's a chance to think that the voice of academics will play out larger in those type of debates external to the academy. Thank you.